Welcome to Dr. TSPR show. This is Dr. Tangella Shiva Prasad Reddy alias Dr. TSPR. Namaste, Adab, hello. I have the esteemed guest in Sri B.V. Acharya Garu. And before I introduce B.V. Acharya Garu, let me make it very clear to all the viewers that in the spirit of the freedom struggle, we are trying to see to that every citizen of this country, even NRIs, they understand what Constitution is in the simplest way. Right from the first citizen of India, Honorable President, to the first citizen of village panchayat, the Sarpanch, right from the Honorable Prime Minister to Honorable Chief Ministers and many other dignitaries, right from Chief Justice of Supreme Court of India to Chief Justice of respective High Courts of the states. Everyone, they take oath on the Constitution of India. So what is that Constitution which binds India? That is what we are trying to unravel. In this series, today, we have taken up the topic of power of Parliament to amend Constitution, its limitations. So we have one of the eminent lawyers in India as our guest today. He is Mr. Sri B.V. Acharya, Senior Advocate, Bangalore. Let me give you a brief profile. Sri B.V. Acharya, hailing from Belpu village of Udupi district, had his early education in Mangaluru and obtained law degree from Madras University in the year 1956. He was enrolled as an advocate before the High Court of Mysore on 29th August 1957 and set up practice in Mangaluru. In 1972, he shifted practice to Karnataka High Court, Bangalore. He was the chairman of the Karnataka State Bar Council between 1979 and 1982. He has practiced in all branches of law. He has practiced on original side as well as appellate side. He has practiced before the courts at all levels in the country, right from the court of Tahsildar up to the Supreme Court. He appeared as special public prosecutor in many sensational cases. He has also appeared before many commissions of inquiry. He was designated as senior advocate by the High Court of Karnataka during May 1989. In December 1989, he was first appointed as Advocate General of Karnataka. In all, he held this said post 5 times. In itself, it's a record. He has served as director of the Karnataka Bank for 8 years from 1996 up to 2004. In 2005, he was appointed as special public prosecutor in the disproportionate assets case against Selvi Jayalalitha, former Chief Minister of Tamil Nadu, and others. In that capacity, he appeared and argued the case before Supreme Court of India also. In 2006, he was honored by the High Court of Karnataka during its Golden Jubilee celebrations on his completing 50 years of practice at the bar. In January 2009, the Mangalore University conferred on him honorary doctorate, recognizing the service rendered by him in the legal field. He has received many awards. For a term of 3 years, August 2009 to 2012, he served as the chairman of BMS Education Trust, which managed various prestigious educational institutions, including 3 engineering colleges and 1 law college. He served as a member of the 19th Law Commission of India with a term of 2 years from 2010 till 2012. In November 2014, his autobiography, All From Memory, was released by the Chief Justice of Karnataka, Justice D.H. Waghela, in the presence of former Chief Minister Sri M. Veerappa Moily and Sri K.K. Venugopal, the then Attorney General of India. On 28/10/2017, Sri B.V. Acharya was felicitated on his completing 60 years of practice, gentlemen, at the bar. The function was presided over by Justice M.N. Venkatachalaya, former Chief Justice of India, with Justice L. Nageshwar Rao, Judge Supreme Court of India, and Justice P. Vishwanath Shetty, Honorable Lok Ayukta, as chief guests. In the same year, Bar Association of India honored him with Lawyers of India Day Award. Presently, at the age of 86 years, he is in active practice before the High Court of Karnataka, having completed 63 years at the bar, including over 30 years as a senior advocate. I really take this as a better moment in my life to introduce such stalwarts. His biodata speaks immense talent in that particular field. The way he has held his positions, really, we salute you, sir. I honestly welcome you to, sir, go ahead, sir. Yes, sir, you can go ahead.
Dr. Tangella Shivaprasad Reddy, all the participants and the respected invitees, and my dear law students. At the outset, let me thank the organizers of this function for giving me this opportunity to share my thoughts with all of you on this important topic of the power of Parliament to amend the Constitution and its limitations. In the words of famous lawyer and jurist of India, late N.A. Palkiwala, Constitution is a sacred document meant to impact momentum to the living spirit of rule of law so that democracy and civil liberty may survive beyond the passing hour. Now, the Constitution of India is hailed as one of the best federal constitutions in the world, if not the best. The Constituent Assembly, which consisted of stalwarts and eminent jurists of the time, discussed the matter in great detail for several months, and ultimately the Constitution was approved. The Constituent Assembly was presided over by Dr. Rajendra Prasad, and the B.R. Ambedkar was the chairman of the acting committee. Now, while people know all these facts, one important person contribution is not generally known is the contribution of Sir B.N. Rao, who was the constitutional advisor to the Constituent Assembly. Dr. B.N. Rao, that is Benagal Narsingh Rao, hails from Udupi district, and he was selected as ICS on the basis of scholarship, and he was appointed in those days. A person in ICS could be drafted to judicial service. He was appointed as a district judge, and later he was the judge of Calcutta High Court for a number of years. For the purpose of drafting this constitution which he did, he has traveled to several countries, studied the constitutions of other countries, and ultimately the draft was prepared. His role in the preparation of the constitution was praised by all the people, including Dr. Rajendra Prasad. The Constituent Assembly adopted this constitution on 26th of November 1949. B.N. Rao, after working for this constitution in an honorary basis, also thereafter helped other countries to have their constitutions. And ultimately, recognizing his merit, he was elected as the judge of the International Court of Justice, which post he held till he died. After the constitution was adopted, it is on 26 January 1950 that it came into force. This is a constitution which we, the people of India, have given to ourselves. Without going into other details of the constitution, I can only say that we have adopted a British system, parliamentary system for our governance. We are a republic, we are a democracy, and essentially there are three organs of the state in our country, that is the legislature, executive, and the judiciary. The powers and duties of each one of the organs is clearly delineated in the Constitution. The powers and duties of the states and the center and the relationship between the two are also enumerated. It is stated that our Constitution is one of the lengthiest or the lengthiest Constitution in the world, having nearly 400 articles and several schedules. Now, Constitution, as I said, is a document not like ordinary legislation. For the time being, it will be a sacred, permanent document which will guide the nation and the governments that will rule. Now, naturally, the founding fathers of the Constitution felt that there should be a provision for amendment of the Constitution. It can't be static. It may require changes. Therefore, in the Constitution, Article 368 is introduced, and it has been there from the beginning, which gave power to the Parliament to amend the Constitution. It only said that the bill for amending the Constitution should be passed by a majority of the strength of the Parliament and 2/3 majority of the members present and voting. This is the requirement. And in respect of certain articles which deal with the state subject, it also requires the ratification of the majority of the states. This is all the provision in the Constitution. This Article 368 is the source of power for amending the Constitution, and the Constitution has clearly given this power to the Parliament. To this extent, there is no difficulty. Further, in the article, there is absolutely no limitation or restriction placed on that power. It is an absolute power, and it is an unlimited power if you merely read the text of Article 368. Now, soon after we became a republic, state governments wanted to bring in land reforms. That is in pursuance to the policy that tiller should be the owner of the land, agricultural lands. Therefore, Zamandari Abolition Act and such other local were enacted by the states to bring in land reforms. When these acts were enacted, immediately the landlords in their land approached the courts and contended that these legislations are violative of fundamental rights guaranteed by the Constitution, and therefore these acts will be declared as unconstitutional. At this stage, I may say, in the Constitution, Part 3 deals with the fundamental rights of the citizens. And in Part 3, Section 13.2 says that no law will be valid if it violates the fundamental right guaranteed by Part 3 of the Constitution. And the Parliament, the Supreme Court and the Superior Courts, High Court and Supreme Court have the power to strike down any law if it infringes the fundamental rights guaranteed by Part 3 of the Constitution. These legislation of land reforms were struck down by the courts, holding that it is violative of fundamental rights guaranteed under Part 3. Now the government wanted somehow to save these legislation and also intended to have future legislation for various economic development and social reforms. Therefore, the Parliament decided to amend the Constitution so as to protect these land reform measures and other reforms which they wanted to bring about. Their Constitution was amended and A and B was introduced first by the Constitution Amendment. This Constitution Amendment itself was thereafter challenged before the court. And the Supreme Court, on an analysis of the matter, held that the Parliament had the power to pass this amending bill, and therefore the amendments effected were approved by the, confirmed by the Parliament. Thus, the judiciary recognized the power of the Parliament under the amendment. Were effected for various purposes, including an amendment regarding Schedule 9, where all the acts that were incorporated were beyond challenge before a court of law. Therefore, with this, from the year 1950 till about the year 1967, for 17 years, the accepted position was that the Parliament was entitled to amend any part of the Constitution, and all the amendments brought about by the Parliament during these 17 years were upheld, and there was no dispute. Then for the first time, dispute arose in the year 1967. In the year 1967, Supreme Court gave a decision in a case which is popularly known as Golaknath case. It is a case of Golaknath versus State of Punjab relating to the validity of the amendment brought about by the Parliament. That case is a very important case where 11 judges of the Supreme Court sat to hear the matter. At that time, I think there were only about 16 judges, but 11 judges sat. And Chief Justice K. Subbarao was the Chief Justice of India. He constituted this bench. As you all may be knowing, Justice K. Subbarao was a great legal luminary and he was very, very enthusiastic to protect the rights of the citizens, and in particular, he always stood for fundamental rights being protected. So in this 11th bench, a contention was urged that whatever be the power of the parliament to amend the constitution, that amendment must conform to fundamental rights. Because I said earlier, Article 13.2 said, any law which contravenes fundamental rights is bad. Now, a view is taken that even a constitution amendment is law within the Article 13.3, and the constitution amendment must therefore conform to fundamental rights. If it is violative of fundamental rights, such law will be bad. Therefore, the majority judgment in Golaknath's case, presided over by Justice Subbarao, held that the Parliament has no power to amend any article in Part 3, which is the fundamental rights. The result is, by a majority of 1, 7:6, 7 judges held out of 6 judges held 6:5. They held that you cannot amend Part 3 of the Constitution, that is the fundamental rights. The government was in a fix at that time. They were very eager. There is an earlier position of the unlimited power of the Parliament to amend must continue. If this restriction is placed, it will be too difficult for them. Therefore, the government wanted the reconsideration of this judgment of a bench of 11 judges by a larger bench. In the meantime, certain constitutional amendments were also passed. That is 24th Constitution Amendment and the 25th Constitution Amendment. In the meantime, Kerala also state passed several Land Reforms Act, several amendments to that act. Now, the main Land Reforms Act with amendments were challenged, validity was challenged before the Supreme Court by His Holiness Sri Keshavananda Bharati Swamiji. That is why the petitioner is Keshavananda Bharati Swamiji. Now he passed away only a few days back. That is why in the last few days you find so many articles referring to Keshavananda Bharati case and what is its importance. He filed a petition when he was 30-year-old in the year 1970, and this year at the age of 80 he passed away. Now he filed a petition before the Supreme Court challenging the Kerala Land Reforms Act and also certain constitutional amendments which gave protection to these Land Reforms Acts. So all these matters were clubbed together and the court had to consider the validity of the constitution amendments. 24th, 25th, 26th and 29th, 4 constitution amendments were challenged, which was considered by the bench in this Keshavananda Bharati case. Now this Keshavananda Bharati case is considered as not one of the most important judgment in the history of Indian Constitution. Since Golaknath's case was by a bench of 11 judges. Any ruling to overturn that judgment, overrule that judgment, has to be of a larger strength. Therefore, this case of Keshavananda Bharati was heard by a bench of 13 judges in the Supreme Court. At that time also, I am told there were only 16 judges in the whole court, and 13 of them were asked to, a bench of 13 judges was constituted, and this matter was heard. This is one of the most important cases as I already stated. There is no other case in the history of Indian Supreme Court where a bench of 13 judges have sat. All others are of lesser strength. In fact, 8 times 11 judge bench has sat, and only 15 times 9 judge bench. But Keshavananda Bharati case is the only case in which 13 judges sat and heard the matter. And it is also a matter of record that the case took the longest period of time. 13 judges heard this case for about 6 months, and actually 68 working full days the case was heard by the bench, and all the top eminent lawyers available in the country have appeared. And for the petitioners, the team was led by Nani Palkiwala, and along with him were such great names as C.K. Daftari, Suri Sorabji, and many others. As against that, on behalf of the government, apart from Attorney General Niran Dey, the most famous advocate and jurist, H.M. Shirwai, who was at that time the Advocate General of Bombay, also appeared. Thus, it was a battery of top jurists who appeared before the court and argued these matters. Not only lawyers who appear, both sides produced such voluminous material which you cannot think of at all. If you ultimately see the judgment, it will be found that the constitution of 71 other countries are referred to take a decision in the matter. So many textbooks, not only on law, but also on all other subjects such as science, philosophy, and so many sociology and economics and other things are also produced. And the material produced is so voluminous and varying, and judgments of so many other countries regarding the amendment of the constitution are also considered. In fact, as I said, it refers to the constitution of 71 countries. And one learned judge has said the papers produced are, it is certain acres of papers, and some rivers of ink have been used for preparation of those papers. Such was the volume. And the most significant part of it was the bench is presided over by Chief Justice Sikri, and he was to retire on 25th of April 1973. So they had to give the judgment before that date. After 6 months it was reserved and the matter was pending. and there were both sides were very eager to win the case. Particularly, the government was also very eager to win the case, and it is said the government was trying to somehow postpone the matter so that the bench may be reconstituted, and later on they may, because they were not hopeful of. And recently, after the death of Kesavan Bharat and little earlier, in bar and bench, you have two articles written. One is basic structure doctrine, battle behind scenes, what all battle had taken place, it is mentioned. And another is by unusual happenings in this case by Sanjay Ghosh. And it is said there was so much of pressure that one learned judge felt ill and he got him admitted to the hospital so that the matter will be postponed. And it is said the Chief Justice of India went to the hospital to verify what was the sickness. Then he was told he was suffering from blood pressure. Anyway, I except for interest, it is not necessary to go into these things because so many manipulations appear to have been made behind the scenes. We are not concerned with that. We are concerned with the main position of law and the decision. With all these maneuvers, ultimately, one day before his retirement, on 24th of April 1973, the judgment in this case was pronounced, which is the historic judgment is in Kesavananda Bharati case. Now, there is a split verdict. 7 judges took one view, 6 judges took another view. 6 judges, having the minority view, held that Golaknath case is correct. The earlier, before Golaknath, the law that power of parliament to amend is unlimited, there is no restriction on that power, is correct. Therefore, you cannot place any restriction. Golaknath case is also wrong because it said fundamental rights can't be amended. Even that is wrong. There is no restriction or limitation on the power of the parliament to amend. This is the view minority. But the majority view was otherwise. And the majority of one. Then one case where another important thing of this case is, in this judgment, the closely typed pages, our law books, you have seen, the judgment runs into 700 pages, and the head note pointing out the important aspects decided, both for and against, majority and minority, runs into 100 and odd pages. And the total paragraphs are 2,144 paragraphs judgment. And generally, where there are two views, there will be one majority judgment, one dissenting judgment. Here, out of 13 judges, 11 judges wrote separate judgments. Only 2, Justice Mukherjee agreed with Hegde and Justice Grover agreed with Justice Howard. All the rest wrote separate judgments. So in all, there were 11 judgments written. This is also a record in the case. And Justice Y.V. Chandrachud, father of present Judge Dr. Chandrachud was the junior most judge among these 30. He has also written a separate judgment agreeing with them, taking the minority view that the power of the parliament is unlimited. And in the judgment of Justice Chandrachud, he has referred in 17 paragraphs in all, he has referred only to the materials produced, including more than 25 dictionaries and law lexicons which have been produced by the parties in support of their respective contentions. Now, as I said, regarding the minority view, there is no difference. All said the power of parliament is unlimited. But the majority view of 7, each judge took his own view. And briefly, just in one sentence, I will say what is the majority view. Chief Justice Sikri said, though you have vast power and there is no limitation placed by the section itself, the main contention of the petitioners, Mr. Palkiwala and others, was that though there is no specific limitation, very word amend means there is an implied limitation of the power. Amend doesn't mean destroy or repeal. In the guise of amendment, you cannot make wholesale changes. Therefore, they requested the court to read into the article a limitation on the power, abridging the power which is there to amend. And it should only mean amend and not otherwise. So, this contention is fairly accepted by the majority of the judges, though each one expressed it in his own way. Now, Chief Justice Sikri said, the power does not empower the parliament to completely change fundamental features of the constitution so as to destroy identity. This is how we put it. Not to completely change fundamental features of the constitution so as to destroy its identity. Justice Chalak and Gover said, it the constitution or constitutional structure or denude them of their identity. You can't amend so as to denude the articles of their constitution with identity. Then Justice Hegde said, power, though wide, does not include the power to destroy or emasculate the basic elements or fundamental features of the constitution. Then Justice Jagannath Reddy held that you cannot totally abrogate or emasculate or damage any of the fundamental rights or essential elements in the basic structure of the constitution or destroy the identity of the constitution. These are the 6 views. And the 7th, which ultimately tilted the balance, is of Justice H.R. Khanna. Justice H.R. Khanna said, the power does not include power to abrogate the constitution, nor does it include power to alter the basic structure or framework of the constitution. Subject to the retention of basic structure or frame of constitution, power to amend is plenary. No other restriction. In view of this conflicting, generally each judge reads his judgment and leaves it to the litigants and the lawyers to decide which is the majority view. But in this case, after the pronouncement on that very day, the judgment was pronounced, Chief Justice Sikri prepared a separate note. This is the majority view. Yes. At the end of the judgment, after all the judgment, one note is given which says the view by the majority in these petitions is as follows. One, Golaknath case overruled. Two, this is the only gist with so many pages, ultimate gist of Keshwananda Bharati. If anybody asks you what is the ratio, this is the ratio as accepted by the majority. The Article 368 does not enable Parliament to alter the basic structure or framework of the Constitution. This is the ultimate goal. The rest is not of any consequence. Now this very significantly, even on the question, what is the majority view, all the judges were not informed. This which is given at the end is signed by only 9 of the 15 judges. Other 4 who have dissented, of course 6 have dissented. Of them, 2, Justice Chandrachud and Justice Palekar have signed it, though they are of the minority view. But the other 4 judges did not even sign this. This is one unusual feature of the Constitution. This is one of the matters regarding which there was a lot of debate. But ultimately, as on today, it is accepted that this is the ratio of the case, and it was accepted by everybody. Now, the result of this is one important thing. Power to interpret the Constitution is with the Supreme Court. There is no dispute about it. Supreme Court is the ultimate interpreter of the Constitution. In fact, one American Supreme Court judge has said, Constitution is what we, the judges, say it is. Because whatever interpretation you give, that is the law, that is the Constitution. Text may be different. That is what happens. And I later give an instance where, in the case relating to appointment judges, the Supreme Court said the word in the Constitution is CJI shall be consulted. Now they said consultation means concurrence. Exactly opposite of what they say becomes the law. And today that is the law. So far as appointment of judges, with that we will deal a little later. But the point I am saying is, Constitution, it is the interpretation they give, Supreme Court gives which. So that they have the supreme authority. Now, this decision gave them an additional power to the Supreme Court. Now, what is basic structure? Nobody has said whether a particular amendment alters the basic structure or not. Who has to say? Supreme Court. Now, nowhere is it defined. Even in this very judgment, they have given some illustrations. Without venturing, they could not have done it also, to give an exhaustive list of what is basic structure. So even today, it is in a fluid state. Many items, whether basic structure or not, is yet to be decided. Only the other day, I will give one example. In Rajasthan, anti-defection law, Speaker gave notice to the dissidents. The dissidents immediately challenged the notice before the Rajasthan High Court. And one of the contention was 10th schedule provision which says if a member having been elected voluntarily gives up membership, he is disqualified. Now that itself, they said, is opposed to the basic structure of the Constitution, because Article 19 gives us freedom of expression, and now speech and expression. Now, I am a member of the party. If I say something contrary to the policy, then if I am to be thrown out of the party, that affects my freedom of speech. And that is the basic. It is one of the fundamental rights. Therefore, it infringes basic structure. Therefore, that must be struck off. The provision in part 10. That's all. I am just mentioning to say how these things are still vague. Therefore, ultimately, what happened is, in addition to being the ultimate authority to decide, interpret the Constitution, you have also the right now to interpret what is the basic structure. What they say will be the basic structure. Now, in a number of, before coming to the question of this, what is basic structure, I will deal with separately. The government was terribly upset by the fact that the power of the parliament to amend has been taken away, and it is restricted by this judgment. And at that time, as you know, the government was headed by Mrs. Indira Gandhi. She was terribly upset. No doubt in legal matters, she was guided by Siddhartha Shankar Ray, Law Minister Gokhale, and more than that, Mohan Kumar Mangalam. They were the legal experts on whose advice she was acting. She was so upset. The judgment was pronounced in the morning, and of the judges in the majority, Sikri was there, who was to retire next day. Of the rest, three were Justice Shawar, Justice K. Sigde, and Justice Grover. These three were to be the next Chief Justices on the basis of seniority, which was the convention. But judgment was pronounced in the morning. At 5 o'clock, evening news bulletin radio announced that the government has appointed the fourth person, Justice A.N. Ray, who has given judgment in favor of the government. He was appointed as the Chief Justice of India, superseding these three judges. No doubt, legal fraternity and the people in general were upset. There were strong protests by everybody, but all that protests took over as the Chief Justice very next day. And these three judges had to forgo their Chief Justiceship because of the judgment which they gave, which was against the government, curtailing the power of the parliament. So they too resigned. This is the result of the judges taking an independent view against the wishes of the government and curtailing the power of the parliament. See, C.K. Daftari, who later became a Rajya Sabha member on nomination, referring to this supersession and appointment of E.N. Ray, very humorously said, the boy in the essay contest, the boy who wrote the best essay got the first prize. That is how A.N. Ray, by giving judgment in favor of the government, got the first prize and became the Chief Justice of India, superseding three other judges. Now regarding the supersession, the government had its own defense. Sri Kumara Mangalam and others justified, saying that we want judges towing the philosophy of the government. We can't have a judiciary which is confronting with the government. On the other hand, what he said was, we want forward-looking judges. For that, Justice Hidayatullah, who was known for his wit, remarked, yes, we want forward-looking judges, but not judges looking forward. And today, the situation is the executive has so many avenues to offer to the judges. At least some of them will be forward-looking. One may become a governor, another may become a Rajya Sabha member, another may become chairman of some other commission. This is important. This is how the matter went, and they were so angry about the thing, and this is the price which three judges had to pay. That is one aspect. Then the government did not keep quiet. The government at any cost wanted to see that this judgment in case one on the Bharati is somehow reviewed and reversed. So, with A.N. Ray as the Chief Justice of India, suddenly in 1976, a new 13-judge bench was constituted by him, and the matter was listed before the bench of these 13 judges to review Keshavanand Bharati's case. And when the matter came up, again, Sri N.A. Palkiwala and the entire team very strongly contested the very formation of the bench and the very listing of the review petition before the court. The matter went for 2 days, and I am told Palkiwala was brilliant at his best in putting forth his view that the bench cannot review this matter. It was heard for 2 days, and Palkiwala asked, who is it who wants review? Then Chief Justice said, it is Madras government wants. Then Advocate General of Madras stood up and said, no, we don't want review. Or the Govind Swaminathan was the Advocate General. He said, we don't want to. Then he said, some other ad. So that man also said, no, we have the ad. Then the bench found it, Chief Justice found it very difficult, or whatever be the reason. On the third day, morning, bench assembled. Immediately, Chief Justice announced, this bench is dissolved. No further order on the claim of review by whom, what and all. There it ended. Thus, the first attempt on the part of the government to get it reviewed failed. Even then, the government did not keep quiet because they were in power headed by Indira Gandhi. So they brought in 42nd Constitution Amendment. By that amendment, this is important, 42nd Amendment was brought around about the time of emergency with so many drastic changes in the Constitution. And one of the changes in that enactment was 368 is the article giving power of amendment. Now that did not place any restriction. It is the judgment which is coming in the way. And the judgment had also said the power to amend includes power under 368 also. So the government said Parliament has power to amend even 368, and therefore they added clause 4 and 5 to Article 368. And that Article 4 and 5 was to give unlimited power. By this amendment, clause 4, they said, no law will be void as offending fundamental right if the law is to give effect to part 4, directive principles of state policy, which is not. So to that extent, even if it is violative of fundamental right, if it is consistent part 4, then it will be valid. You can't strike it down. And another amendment 5, clause 5, no amendment made under Article 368 shall be called in question in a court, and that power to amend is unlimited. So to get over this judgment, they brought out this amendment, 42nd amendment. Naturally, 42nd amendment was also challenged before the Supreme Court. And that case in which this amendment was struck down by the Supreme Court is popularly known as Minerva Bill's case. And that is by a bench of 5 judges. They said, in view of the Keshavananda Bharati case, this amendment which you have brought about, 4 and 5, they themselves are violative of basic structure. And if it is violative of basic structure, majority judgment in Keshavananda stands. Therefore, this amendment is bad. Very interesting to know, some of the judges, some 2 of the 6 who are minority view here, Justice Chandrachud is one of them. He also fell in line. He said, whatever be my view, majority view in Keshavananda is binding on me. Therefore, it opposes to basic structure, it is bad. So, the entire constitution bench agreed that this amendment, so as to restore the position and give unlimited power to the parliament, is bad in law and was struck down. With this, one chapter ended. All the attempts of the government to somehow get to the parliament the unlimited power to amend came to an end. And thereafter, after 1980, Minerva Mills case, till today, nobody has challenged Keshavananda Bharati. And now it is too late in the day for anyone to challenge also, because it has stood the test of time, and I don't think any Supreme Court Chief Justice will now constitute a bench of more than 30 judges to reconsider. All that is not practically possible. The result is, as on today, the power of amendment is strictly controlled or covered by the judgment of the Supreme Court in Keshavananda Bharati's case. And that is the law of the land. That is why today, when His Holiness passed away the other day, so many headlines in the newspapers are that here is a saint who saved the basic structure of the Constitution. The person who saved the basic structure of the Constitution. And that is 100% correct. Though in law there may be two views about the correctness of the majority decision on technical ground of power of the parliament, constituent power to amend, the judgment was welcomed by the people in general and even the legal fraternity and eminent jurists, because whatever be the technicality, because of this amendment, today we have this constitution. Otherwise, the way 42nd amendment was brought about, and the way our parliament members are behaved subsequently, as we have seen, they would have amended every article of the Constitution to such an extent that we would not have had this Constitution. And the Constitution would have lost all its identity. Therefore, from experience, we can say that it is this judgment which saved the Constitution and in turn saved the country. Now we are in a democracy. Now, as I said, Keshavananda Bharati is responsible for retaining the basic structure. Times of India, 2 days back, gave a headline stating that Bharati was one of the 9 pillars of the basic structure doctrine. I was anxious to see who are these 9 pillars. When they say 7 of the judges, majority view, and Nani Palkiwala who argued for Bharati, and 9th is Bharati. Thus, of the 9 pillars on which this basic structure stands today, Keshavananda Bharati is one of them. So, in the constitutional history, his name will ever be remembered. And we, the people of the country, will be happy that we have been able to retain this constitution, which in turn led to retention and survival of democracy in this country. Now let me tell you, after this judgment, how so many constitution amendments were passed. Now of them, many have been upheld because they did not violate the basic structure. Now, one of the earliest cases in which this had to be tested was they brought in, because Indira Gandhi's election was set aside by the Allahabad High Court and she was in appeal before the Supreme Court. So, they brought in a constitutional amendment saying that a Prime Minister's election has also, instead of saying only Prime Minister, President and Vice President shall not be questioned in a court of law. Now that was struck down, that amendment was struck down by the Supreme Court holding that holding of a free and fair election is one of the basic structures. Therefore, you can't pass this amendment, and struck down the amendment holding that you can't pass such a law. So today, one item which is held to be basic structure is free and fair election. Any law or constitution amendment contrary to it will be held valid. The second one, that is power of court to go into the validity of a legislation. Any legislation banning law, the court has power to strike down. If any law says the court's power to go into the validity of this will be banned, court will have no power, such a law will be opposed to the basic structure. In other words, it has been held that power of judicial review, which is invested in the superior courts, High Court and Supreme Court, any law which curtails that power will be opposed to basic structure. That is one of the accepted heads of basic structure. Then independence of the judiciary. It is also said to be a basic structure, but I will deal with that separately because all are agreed that independence of judiciary should be a basic structure. You can't ignore it. But at the same time, in finding out whether independence is violated or not, again it is for the Supreme Court. And they are given wrong judgments according to me, in their own favor, which if it is necessary, I'll deal later. But anyway, for the present, independence of judiciary is a basic structure. Democracy is a basic structure. That in the illustration itself, Keshavananda Bharati, they have said, you cannot bring in oligarchy or dictatorship. Democracy is a basic structure. Any amendment which will bring in dictatorship will be opposed to basic structure. So also, rule of law. Ours is a country governed by rule of law. Anything which is contrary to it will be banned. Then separation of powers, executive and the judiciary. That is the basic postulate. The three organs, each is independent. Legislature, executive, and the judiciary. Each is independent of its power. That separation of powers, you cannot mingle. You can't give judicial power to legislature. If you give it, it is bad. In fact, so many special tribunals for tax purposes, etc., constituted were recently struck down on the ground that it offends the basic structure of independence of the judiciary. And now there is a new move to have new law relating to these matters. Then federalism. Now we have a federal structure, states and the center. That you can't tamper. And then secularism. Secularism is also held to be one of the basic features of the Constitution. That is, you can't have something communal or so. So these are till now admitted by judicial decisions as the basic structures of the Constitution. Now you see, what is basic structure, there may not be difficulty to find out. As they say, independence of the judiciary is a basic structure, I think. But what the Supreme Court does is, it says whether a particular enactment violates or not the independence of the judiciary is an open question. Now, Supreme Court says Parliament can't offend basic structure, but can it do itself? According to me, the Supreme Court itself has virtually amended the Constitution, violating the basic structural doctrine in the second judge's case. See, in the second judge's case, that is in the year 1993, the power to appoint High Court, Supreme Court judges vested in the President. President under the Constitution is on the aid and advice, that is central government, to appoint judges in consultation with the Chief Justice of India. That is the exact wording. Now, the power of the executive ultimately to decide. Otherwise, A&Ray would not have been appointed as Chief Justice. And also, subsequently, H.R. Khanna also at that time, because from 1950 till 93, accepted position is, this is the correct interpretation. Government to appoint after consulting the Chief Justice, not concurrence. But, and the question was once raised in 1980, which was first judge's case. By majority, first judge's case in 1980, government wanted to, the Supreme Court wanted to take away the power of the executive and invest it in itself, saying that CJI is the ultimate authority. He has the plenary power in case of disagreement of a candidate. CJI and government. CJI will prevail, not the government. That was the contention. But by a majority of one day, that again 6-5, first judge's case, it is well known as F.C. Gupta's case. The Supreme Court gave a judgment in favor of the government. It said, no, CJI can't have the power. Under the law, under the Constitution, it is the power of the executive. So, contention to them. Now, in 93, another bench said that F.C. Gupta case requires reconsideration. So, the matter, a PIL is filed, can reconsider F.C. Gupta. So, second judge's case by 9 judges, because earlier one was by 7. So, 9 judges. In that case, the question was whether this concurrence, consultation is concurrent, and in case of difference of opinion, CJI's view will prevail or the government's view. They reversed the first order in S.P. Gupta and said it is the CJI's view which will prevail. A judgment given totally contrary to the text of the article, and they said instead of CJI alone, we say it is the collegium which will decide. CJI and two senior most judges will form a collegium, and their work will be final, not of the government. The ultimate power of the executive, that is central government, was taken away and invested in Chief Justice of India and two judges collegium system. Nowhere do you find such an expression in the Constitution. And I, as Advocate General of the state, had argued before 9 judges in the second judge's case. And I was present during the hearing. And they gave a judgment like this, contrary to the text of the judgment. And that, of course, majority, 7/2. Two judges said no, S.P. Gupta is correct. No need to reconsider. But they said no. The view of the collegium will be correct. Then after some years, with this, in 93, for the first time, the power of the executive vested to appoint judges was divested of that power, and that power is vested in the collegium, Chief Justice, and two senior most judges. Now, is this not a basic structure? The basic structure includes the division of powers, an important power of the executive. It tilts the balance. The original constitution maintains a balance between the three organs. This tilts the balance, and according to me, it is one of the basic structure. By this judgment, in fact, all are agreed that this judgment is contrary to the text. And even well-known author Basu has said, in the guise of interpretation, the Supreme Court has virtually rewritten the Constitution so far as appointment of judges is concerned. And instead of amending, it is rewritten by them. Can they do it? Can the judges themselves have a law and amend the Constitution indirectly by offending the basic structure? This is what they have done in the second judge's case. In the third judge's case, they slightly modified this. Chief Justice and two senior most judges in the case of appointment to the High Court. But in case of appointment to Supreme Court, it will be Chief Justice and foremost judges, senior judges. That is, collegium will be 5 for Supreme Court. For all this, there is no basis in Constitution. It is judgment law. And as on today, so from 1993 till today, that was changed. Now, throughout there was clamor. The appointment by collegium was unsatisfactory. I am not going into details. Even judges themselves have said that is the subject of many discussion. In fact, I have also quoted many Supreme Court judges who are members of the collegium saying that this is very bad. Things are not being done properly. So throughout there was clamor for a national judicial commission to recommend and select judges. So though the government was eager, they were not able to do it. But for the first time, the present government brought in the legislation, that is 99th Constitution Amendment, 99th Amendment and National Judicial Appointment Commission Act, a Constitution Amendment and an Act to provide for a commission to select judges instead of collegium. That is what they did. The Act did not give the power back to executive, but an independent commission. It comes 6 members. Of the 6, 3 are Chief Justice and 2 senior most judges. So predominant say, because it is appointment to judiciary, 3, they will be there and presided over by CJI. The other 3, one will be the law minister representing executive. 2 will be civil society, third parties, 2 eminent citizens to be selected by the Committee of India, Prime Minister, leader of the opposition. Please see the composition. Even politically topmost Prime Minister, leader of the opposition, they select 2 eminent people. These 6 will be the commission. Now this, one of the very unusual things in our Constitution Amendment was passed, 19th Constitution Amendment passed unanimously by the Lok Sabha and almost unanimously by the Rajya Sabha with one opposition. So in effect, it is a unanimous decision by both houses. And most unusual, they are all coming together for this independent body to selection of judges. Now this is challenged. And a 5-judge bench, Constitution bench, says, no, by constituting this commission, you have taken independence of the judiciary is a basic structure. Now, this law amendment takes away the basic structure. Therefore, it is violated. My submission is, it can never be said that it violates the basic structure of the Constitution. Basic structure was violated by the judges in the second judge's case. Here, they are only, instead of giving the power back to executive, you are giving it to an independent body. Now, according to my knowledge, in the whole world, there is no country where judges appoint themselves. Here, they appoint themselves. And by this judgment, they erroneously said this constitution of an independent body. They say, law minister being there, executive is represented, it will be bad. If a law minister should not be there in the selection process. In all other countries, executive has the main say. And in no country, judges appoint themselves. Can we say, in no other country, there is independence? The judiciary is not independent. Therefore, by this erroneous decision, here it was majority of 4-1. Justice Kalameshwar, in a very beautiful judgment, upheld the validity of this amendment, while 4